Hi, thanks for clicking in and thank you for joining us for another episode brought to you by me, Amy Maserati, your premier real estateologist. Real quickly, the subject of this video is selling a property that's in probate in Florida. This is where I'm going to shine, people, with my experience as a real estate and probate attorney for 30 years in the state of Florida. I have some good tips for you. So if you find yourself being the personal representative, or some people call it the executor. In Florida, we call it a personal representative in charge of selling the assets of a probate after a loved one dies. Listen to this video. So here's what we've got. Basically, probate, when you're selling a property in probate, it's really walking through a legal proceeding. It's not a normal real estate transaction. Yes, you're selling a piece of real estate, but the rules of engagement are governed by the Florida laws of probate. And that can be testate or estate. Testate means that the person who died and left the assets, they died with a will in place. So a will is going to be filed with the court, a probate case is going to be open, letters of administration are going to be issued, and a personal representative is going to be appointed. Then you can get started on disposing of the assets. But all that stuff has to happen first. So, contrary to popular belief, when someone passes away, or if you're the one who's preparing for your own passing away, people can't just sell your property. Easy peasy. You need to make sure that you know who it's going to. Now, there are ways to avoid probate. While you're alive, you can transfer title, and you can create a trust, transfer title into your trust. And then when you pass away, the people that you want to get your property, they'll just get it by operation of law. If they're going to sell that asset, then they can sell it pretty easily. You, as the trustee of the trust, sell the asset, no probate required. There's also what they call ladybird deeds, and that's conveying property. Say, for instance, I have my house and I want my daughter to get it. I'll just do a ladybird deed, transferring title from myself to myself as to a life estate, and the remainder to my daughter. Boom. All she has to do is record a death certificate and title can change. But you have to, if you don't do those things and you prefer to transfer your assets after death via a will, then that's what you'll do. You'll draft a will, you'll designate your beneficiary or beneficiaries, and then your beneficiary or beneficiaries will have to go in to the court, hire a lawyer. You can do it without a lawyer, but I don't recommend it. It's really kind of tricky, the probate stuff, and it's time consuming, and you can get snagged up on little things. There are different rules for different property types, such as homestead, non-homestead, out-of-state assets. There's a lot involved in a real estate transaction. So I recommend that you have an attorney involved when you're providing for disposition of your property after your death, or when you find yourself serving as a personal representative to dispose of the assets for your loved one. So I'm going to stick on this video to probate, selling properties out of probate, because I could go off into all kinds of crazy rabbit holes here. And if you want to go into rabbit holes and estate planning, hit me up in the comments, by text, by WhatsApp, call me, whatever way. I'm happy to direct you and assist you with estate planning. Now, I don't do that anymore. I've retired out of the practice of law, but I know really good attorneys that I have used and I have worked with. So hit me up if you need some recommendations there. And don't forget to subscribe to my channel, share this video with anyone that you think might benefit from this. Okay, so now I'm going to get back to the topic, selling a property. So if you're the PR, personal representative, I might say PR throughout this video, here's what you have to do. I know it's hard. I know it's a horrible thing to cope with the death of a loved one. And if you're the PR, you probably knew that person very well, but you're going to have to find the strength that they're going to want you to, and you're going to have to move on this. unless you're going to keep the house and stay in there and there's no other beneficiaries, that's a different story. But I'm talking about if you're in charge of selling property and liquidating it so that the beneficiaries can get the money, then you need to buckle up, pick yourself up by your bootstraps, and just do a few things. Call the probate attorney. Again, if you need a recommendation in South Florida, I'm happy to help. If you need in any part of Florida or anywhere else, I can find someone good for you as well. A buddy of mine, I helped him find a terrific estate and probate attorney in Connecticut. He lived in California. Anyway, I digressed again. But so you need to get past the grief as soon as possible. Call a probate attorney and get started. So what do you have to do to get started? The attorney will let you know, but primarily the goal is to get the probate estate filed. It's actually a lawsuit. It's not a lawsuit suing people necessarily, but it's a court case called a probate. Probate gets filed, a petition for administration gets filed, the assets get listed in the inventory, and you get appointed as the personal representative, and letters of administration are issued. Those are the first steps, and you have to do those preliminary steps in order to sell the property. You have no authority to sell the property without letters of administration being issued by the court in Florida. So contrary to that popular belief, you can't just like say, oh, well, you said that, I'm the daughter and I can sell it. No, you're the personal representative who happens to be the daughter, but you have to open that probate case and get the letters of administration issued. At the same time, while your lawyer's working on that, you need to maintain the property. So if you live out of state, then you need to either look at it or get a key to your real estate professional to open up, have a look at it. You guys can FaceTime, you guys can look together and discuss the condition of the property and determine if anything needs to be done to preserve that asset. This probate's going to take a little time, okay? It's months-long process, not weeks like a normal real estate transaction. And that's months from you getting your letters of administration issued. That could take a month or two, depending upon the court schedule and how quickly your attorney works on it, and as long as everyone is getting along. But even if people aren't getting along, like any beneficiaries named in the will, still you can get those letters of administration issued. It's a little bit different process. Testate being a will was left and you're following the directions in the will. Intestate means there was no will, but there are descendants of the decedent, who's the person who passed away. And Florida has a blueprint right in the statute that tells you who gets what when someone dies. Those first a percentage to the spouse and the remainder split with the children. If there's no spouse, then the children. If there's no children, then it goes down this whole family tree. It takes a lot for the state of Florida to get it. I've really never seen that happen in 30 years, but I've heard of it happening. I've read cases of it happening, but most of the time there's family, you're going to get it. Most of the time there's a will. So you're going to follow the directions in the will, and you're going to follow the Florida statute on probate. So that's the first thing. Basically, I had like a few things outlined that you need to know as overall. You need to know what is a probate, which I just kind of explained to you. You need to know who has the authority to sell. You need to understand the timing and the process, and you need to hire the right professional. That's really it. So drilling down to each one of those, you need to understand what the probate means. We talked about that, testate versus intestate. Get to the lawyer and just know that it's a legal process, not a typical real estate closing. You need to know who has the authority to sell the property. That's the court-appointed personal representative via the letters of administration. You need to understand the timing and the process. Okay, just understand it's a legal process and the timing is months. Now months is the fastest I've ever seen it. So anyway, the fastest would be like 3 months. typical is 5-6 months to liquidate a property in probate. And you need to hire the right professional, like me, for instance, because I understand the probate. And if it's not me, hire a realtor that understands how a probate works and that can work in concert with the attorneys and the court and nudge the attorneys if they need to, and just get everything lined up so that you can have a nice, smooth process with the cam back. So now, prepping to have a good process with the court and with the sale includes maintaining the property. So while your attorney's doing all that work and getting the letters of administration issued to allow you to meet with your realtor and sell the property, which you should do before, try to pick your realtor out right away too, if you can, because the sooner your real estate professional is involved, the sooner you can get another set of advice. Your attorney's going to give you advice from a legal perspective. Your realtor is going to give you advice from the real estate sales perspective. And much of that advice is, primary part of that advice is, you have to maintain the property. And when, you're not making money from the probate, and here you are with this property that's costing money, you have to take care of it on top of it. So maybe there's a mortgage. So maybe you need to talk about making some calls to the mortgage company and asking for a deferment. Maybe taxes are going to come due. So you don't have to worry about those immediately, because in Florida, you're not in danger of losing the property at auction until the taxes are delinquent for 3 years. But if they're already delinquent, you never know. Sometimes property's inherited that is delinquent in taxes and even mortgage payments, then you're going to have a few other issues to deal with. So you need to get the whole big picture and see what's involved in preserving that asset so that you can get it on the market and get the maximum possible price for it. You're going to have investors coming at you probably right away. They're going to read the obituaries. They're going to find out. It's what they do. They find out when people pass away. And then they immediately do a search for heirs, and they'll be calling all the beneficiaries, maybe not even you as the personal representative. And then you might get a call from your siblings or somebody else saying, hey, this guy called me. He said he'd give me cash for the house. Beware on those guys. You can keep them in your back pocket, but for you to maximize the dollars for the beneficiaries, it's best to put it on the open market and have some competition going on. Unless there's some extreme circumstance where you can just let it go quick, cheap, whatever, do that. But don't forget, you as the personal representative have a fiduciary duty to the beneficiaries. Let me repeat that. You as the personal representative have a fiduciary duty to the beneficiaries. So if you don't maximize the price on this property, the beneficiaries could sue you for breach of your fiduciary duty. So you being appointed the personal representative is a job, and it's a lot of work. I've done it before, and it's a lot of work. You have a lot of responsibility, only one of them being to sell the property or properties. You have to file tax returns for the estate. You have to have that fiduciary duty to the beneficiaries and make sure you're not giving stuff away to people for too little money, like that. So, and I want you to note this as well, because this is another common misconception. People are like, oh my God, it's going to take years for the estate to be closed. It might take years for the estate to be closed, but you don't have to wait until the estate is closed and the final accounting is done to sell the property. It's quite routine that the property is listed, you get appointed, you list it for sale, you market it, you get a buyer, you get a contract. That contract then is submitted to the court for review. Sometimes the courts will ask for an appraisal. Sometimes they'll ask for a realtor's opinion, depending upon the budget and the type of property. And they do that because the court is being asked to approve this contract of sale. The judge does not want to approve a contract of sale unless he or she knows it's fair. So appraisals and realtor opinions on value help the judge make that determination and make sure that you're not just giving the property away and basically screwing the heirs out of their money, and yourself too, if you're an heir. Anyway, so that process happens. You get approved, authorized to sell, you list it, get it under contract. Now you have to put the brakes on, submit that to your attorney, that offer, the one that you like and you pick, and say, here's the offer, here's the contract we want to proceed under. Here it is. The lawyer will submit that to the court with a petition for an order authorizing sale. It's easy peasy for the lawyers. They do it every day, but they need to back up why they're asking the court to approve the sale, because it's a fair price. It's an arm's length transaction. Nobody is objecting like that. So generally, if there's no objection from the heirs or the beneficiaries, the judge will enter an order approving the sale. Once that's done, you're clear to close. The title company will be great. Here's the deal. They close it according to the terms of the contract, and the judge has approved it. It closes, and then what happens is the money is dispersed to the estate. So when you open up that estate, and once money starts to get generated, for instance, from the sale of a home, many judges, most judges in South Florida anyway, will require that you open a designated depository account, a restricted estate account. And then the money just goes into that account. It's just like an account for the estate, just like any other account. The money goes in there and it sits. And you close the deal. Thank you, Mr. Buyer. Enjoy the home. I wish you luck. And then that money later, you'll talk to your attorney, see if you have other assets to sell. Once all the assets of the estate are sold and liquidated and into the account, and everybody wants it to go that way, then the expenses get paid and the money gets dispersed to the beneficiaries. So that's another thing to remember. So just because you sell a property and, you know, the cash due at closing and that gets put in the account is, let's say, $500,000 net proceeds to the estate, that's great. But all the beneficiaries are not going to get to split that money up. What comes off the top? Funeral expenses, if they're unpaid. If anybody did pay for funeral expenses, they get reimbursed. So funeral expenses, or the person that laid out the money for funeral expenses, comes off the top. Then any claims that are filed in the estate and any debts owed by the decedent, they get paid next. And then after that come administrative and attorney's fees. And then after that come your personal representative fees. And many people waive it, but I'm telling you, if it's a decent size estate, it's going to be a lot of work. So talk to your attorney before you consider waiving personal representative fees. Believe me, you're going to earn them and more. And then, so after all these fees get paid, you know, funeral, debts, administrative attorney, and personal representative, then the rest of the money gets distributed and divided between the heirs and beneficiaries as outlined in the will. That may or may not be equal. It depends on what the will says. You're constantly referring back to the will. So that's really what I have. Oh, and the other thing to know is there's another little tricky little puddle in the probate process. If the property was the homestead of the decedent, then there are some different rules for that. If there's a spouse around, and the main thing is that you must have the consent of all of the beneficiaries or heirs. If any one person objects to selling that house, you're not going to be able to sell it to a third party. You're going to have to work it out. I talk about buyouts and things like that, and see if you can. There are a lot of other ways to resolve it. Just depends on what the facts are, right? Is that person that's objecting to the sale a person that's living in the house and they want to keep living in there? Well, then you guys can talk about that and figure out how you can make that happen. So just remember about homestead. So that's it. So the bottom line is that selling a probate property in Florida is a legal process, not a typical real estate transaction. So if you want more information on how this works, or if you want me to help you in that process, reach out to me. Email me, call me, text me, WhatsApp me, whatever way you want to do it. I'm here for you. And if you already have a realtor that you love and trust, But if you just have a few little questions that you want to verify with me, I'm happy to do that. I'm happy to talk with your realtor and do what we can to make this process easy on everyone. So thanks again for your time. Don't forget to subscribe to my channel, share the video, hit like on the video, help me with the algorithms, and have a fabulous day. Coming to you from South Florida on a beautiful December day, I am Amy McGrady, your real estateologist. Thank you for joining. Peace.